Hello friends, welcome to our channel Khatri Steno. So be ready for the dictation without any stop. The first question is whether it is necessary that the legislature should make law uniformly applicable to all religious or charitable or public institutions and endowments established or maintained by people professing all religions. In a pluralistic society like India, in which people have faith in their respective religions, beliefs, or tenets propounded by different religious or their offshoots, the founding fathers, while making the constitution, were confronted with problems to unify and integrate people of India professing different religious faiths born in different castes, sects, or subsections in the society, speaking different languages and dialects in different religions, and provided a secular constitution to integrate all sections of the society as a united Bharat. The directive principles of the Constitution themselves visualize diversity and attempted to foster uniformity among people of different faiths. A uniform law, though, is highly desirable. Enactment thereof in one go perhaps may be counterproductive to unity and integrity of the nation. In a democracy governed by rule of law, gradual, progressive change and order should be brought about. Making law or amendment to a law is a slow process, and the legislature attempts to remedy where the need is felt most acute. It would therefore be inexpedient and incorrect to think that all laws have to be made uniformly applicable to all people in one go. The mischief or defect which is more acute can be remedied by process of law at stages. We are not impressed by the arguments to accept the contention that the law declared in Sarla Mudgal's case cannot be applied to persons who have solemnized marriages in violation of the mandate of law prior to the date of judgment. This court had not laid down any new law but only interpreted the existing law which was in force. It is settled principle that the interpretation of a provision of law relates back to the date of the law itself and cannot be prospective from the date of the judgment, because consideredly the court does not legislate but only give an interpretation to an existing law. We do not agree with the arguments that the second marriage by a convert male Muslim has been made offense only by judicial pronouncement. The judgment has only interpreted the existing law after taking into consideration various aspects argued at length before the bench which pronounced the judgment. The review petition alleging violative of Article 20 bracket 1 of the Constitution is without any substance and is liable to be dismissed on this ground alone. In the light of the legal position as enumerated herein above, let us examine the grievances of the petitioners in the instant case. In review petition, the notice issued was limited to the question of Article 20 within bracket 1 of the Constitution. It was contended that the judgment of the court entailed a convert to Islam the liability of prosecution for the offence of bigamy under section 494 of the Indian Penal Code, which would otherwise not be an offence under the law applicable to him.